I would start out by saying that I am a believer in the institution of the International Criminal Court. So I come to the topic of who's afraid of it as a bit of a flag waver. I guess it's probably good to state my position in relation to it. I don't think it's a perfect institution. It's not a panacea for the ills of the world, but I happen to believe that it is a great advance over what we didn't have before it. And there are some people in the world who are rightly afraid of the court. There are some others who are probably wrongly afraid of it, and there are some others who ought to be afraid. And I'm going to try and deal with each of those different categories in time. But let me begin, before I launch into who's afraid and who isn't and why they should be or why they shouldn't be, with some preliminary comments and also a few fundamentals about what the International Criminal Court really is, because I'm sure not everybody in the room is as familiar as some others about this new institution. Well, I still think it's a new institution. It's now 8 years old. One of the Crown Princes of Jordan, His Royal Highness Prince Said, who is known to quite a few people in the room and a very impressive person in the context of multilateral fora around the world, a huge advocate for the International Criminal Court, in fact, and Prince Said led the Jordanian delegation at the Rome Diplomatic Conference back in 1998 when we negotiated the statute for the court. He did a fantastic job in that conference, and I personally believe that he was single-handedly responsible for convincing the Arab bloc of states not to vote against the statute but to abstain from the vote, which was a huge achievement. He's still advocating for the ICC, and he has said on a number of occasions, most recently in Canberra just a few weeks ago, that in his view the International Criminal Court represents the biggest threat to sovereign excess, the most significant single contribution to a universal rule of law since Magna Carta in 1215. Another 5 years and we're celebrating the 800th anniversary of that great document. That's an amazing anniversary. But Prince Said made this huge claim. I was taken aback by that a little bit when I heard it, most recently just a few weeks ago, and I've been trying to think it through on and off ever since. I don't believe that Prince Said was suggesting that the International Criminal Court has radically transformed the geopolitical landscape in a way that suddenly everyone respects the rule of law and does that consistently. I don't think that's what he means by the claim that he's made. There are some major limitations to the International Criminal Court's jurisdictional scope, to the cases that can actually come before the court and be tried before it. But I do think what he is suggesting is that the International Criminal Court has the potential to help end. We have a few phrases that we keep using, become a little bit cliched perhaps, but this institution has the potential to end impunity for atrocity in a way that has been really unprecedented for a long time. We take the period between Nuremberg and Tokyo and in the late 1940s and the establishment of the International Criminal Tribunal for the former Yugoslavia in 1993 and the proliferation of special courts and tribunals since then. That period of around 45 years, for me, represents the single greatest argument for the importance of an effective multilateral criminal tribunal, because of a litany of individuals who ended up experiencing or benefiting from impunity for the atrocities they were responsible for perpetrating. Prince Said's claim is that the International Criminal Court represents the single greatest challenge to a perpetuation of that sort of experience. I thought it'd be good to try and test his claim in answering the question, who's afraid of the International Criminal Court? But before I try to do that, let me just make one observation. In any celebration or praise of the contribution the International Criminal Court might make, it is important, I think, to acknowledge that its principal contribution will only ever be reactive. The court will try individuals for alleged war crimes, crimes against humanity, or acts of genocide. Those acts will have already occurred when the cases come to the court. The court isn't going to prevent those acts occurring. There are arguments about whether its creation and its operation can have a deterrent effect, and maybe that will be possible in some circumstances. But when some of us get excited about the establishment of this new criminal court, we have to remember that unfortunately it is because it is dealing with atrocities, and unfortunately, tragically, human beings seem spectacularly capable of wreaking terrible atrocity on fellow human beings. So I just want to make that observation before we start. I don't want to get into talking about some of the achievements the court's made without reflecting on the subject matter that we are concerned with here. Sometimes at the law school, we talk with the students about how this is an exciting time to be studying international criminal law. Yes, but for the wrong reasons, and it's, I think, important to keep that in mind. Well, let me try and give you what I would call some international criminal court fundamentals. What is this new institution? How does it operate? What are the ways that cases come before it? Before we move on to try to answer, or to begin to answer the question, who's afraid of the International Criminal Court? This new institution, I keep calling it new, like I said, I guess I'm not sure whether after 8 years it still is or not. I feel like it's just getting going. Has been established in The Hague, the capital of the Netherlands. I had a very interesting conversation just last night with an expatriate Australian who's been working for Microsoft in the US. What's in The Hague? He said, well, there's some canals, some beautiful buildings, there's a lot of Dutch people. Well, there's some pretty important international judicial organisations there. And the Dutch have done a fantastic job, I think, at snaring The Hague as the international legal capital of the world. That's how they're characterising it. Geneva and New York can be the multilateral political capitals, but we have secured The Hague as the international judicial or international legal capital. And it's true. International Court of Justice, the Iran-US Claims Tribunal, the International Criminal Tribunal for the former Yugoslavia, and now the International Criminal Court are all based there. Oh, and coincidentally, Europol has its major headquarters there too. So, in The Hague, in 2002, the Rome Statute, which had been open for signature in 1998, was entered into force, and as a consequence of that, the court was established there. The 18 inaugural judges, the prosecutor and the deputy prosecutors, the registrar and the deputy registrar were all sworn into office in a ceremony in March 2003. And since then, the court has been up and running, so to speak. Investigations commenced and indictments were issued, and now the first 2 trials are underway and a third is about to start in a couple of weeks' time. It's important to understand that the International Criminal Court is the world's first permanent international criminal court. All the other historic precedents have been ad hoc tribunals set up for specific conflicts. So Nuremberg and Tokyo are perhaps the best known of them, set up post-World War II by the victorious Allies for the prosecution of senior German and Japanese defendants respectively. But more recently, in the 1990s and into this decade of the noughties, we've seen a proliferation of ad hoc international criminal courts and tribunals. First, the Tribunal for the former Yugoslavia, then the Tribunal for Rwanda, and then the Special Court for Sierra Leone, the Serious Crimes Unit in East Timor, the Extraordinary Criminal Chambers for Cambodia, and the Special Tribunal for Lebanon. But all of those have been established, as I said, ad hoc for specific conflicts. The International Criminal Court is not like that. It's not set up for a single conflict. And theoretically, it has jurisdictional scope around the world into the future. The International Criminal Court has also not been established by the winning side after a conflict and imposed on the losing side, and that's also a very significant advance over earlier historic models. The International Criminal Court is not set up, though, to replace or to usurp the primary authority of national courts. The statute says in a number of different places that the rationale for the establishment of the court is to complement national jurisdictions, to assist where national jurisdictions are either unwilling or incapable of dealing with the justice issues that are flowing out of the perpetration of atrocity. The court has jurisdiction over individuals for war crimes, crimes against humanity or acts of genocide occurring after the 1st of July 2002. That was the date the Rome Statute entered into force, and the court has no retrospective jurisdiction. It's only prospective from the date of entry into force. And very recently, just a couple of weeks ago, and my colleague Dr. Carrie McDougall was present and negotiating in Kampala. The first review conference of the Rome Statute was held, and it achieved a very significant and historic breakthrough, with adding to those three core categories of crimes the crime of aggression, having reached agreement on a new definition for insertion by amendment into the statute, and it will take effect at a minimum 7 years from now, depending on whether or not a sufficient number of states ratify that new amendment or agree to it. And then after that, aggression in certain limited circumstances will also be triable by the International Criminal Court. Okay, let me explain a couple of other things about the way the court's jurisdiction works, how cases come to the court. There are three triggering mechanisms, they're called, three alternate ways that a case can come to the court. The first of those is by UN Security Council referral. So a majority of the members of the UN Security Council, without a negative or veto vote by one of the permanent members, refers a situation to the prosecutor, and the prosecutor then has the authority to investigate that situation. And that has happened in relation to the Darfur situation in Sudan. Under Resolution 1593, the UN Security Council referred the Darfur situation to the prosecutor. The prosecutor then had the authority to act on the basis of that referral. He did that not only in relation to the former Foreign Minister of Sudan, but also, as you all know, I'm sure, the President himself, Omar al-Bashir. And that is has been a very controversial indictment, and we'll talk a little bit about Omar al-Bashir and the government of Sudan as being one of those categories of people afraid of the International Criminal Court. We'll come on to that. The second triggering mechanism is what we call a state party referral. A state which has ratified the Rome Statute refers a situation to the prosecutor. The prosecutor then has the authority to act on the basis of that referral. And in relation to this triggering mechanism, there are actually three separate situations that have been referred to the court. The conflict in the Congo, the conflict in the north of Uganda, and the conflict in the Central African Republic. In each of those cases, the three governments involved in those civil conflicts, as states parties to the statute, went to the prosecutor and said, we really need some assistance with prosecuting those allegedly responsible. Please help us out. And the prosecutor, on the basis of those referrals, has had the authority to investigate the situations. He's issued indictments in respect of them. The two trials currently occurring at the court are both from the Congo conflict. The third trial, which is about to start in a couple of weeks, is the first trial from the Central African Republic conflict. I'll make some more comments about some of those situations perhaps later on as well. The third triggering mechanism, interestingly, is the prosecutor acting on his own initiative. His own initiative, because at the moment the prosecutor's a man, but that doesn't mean that will always be the situation. His term, Mr Ocampo's term, expires in the middle of 2012, and we'll see who replaces him after that. But the prosecutor has the capacity, on the basis of their own initiative, to go to a pre-trial chamber. There's a sort of additional check and balance built into this particular triggering mechanism, all because of concerns about rogue prosecutors acting on political whims, going after people that they don't like or nationalities that they don't really take a fancy to. Prosecutor, if he wants to act on his own initiative, has to convince a majority of 2 judges in a pre-trial chamber of 3 that there is a prima facie case here. And if he has the support of at least 2 judges, he then has the authority to investigate the situation and to issue indictments subsequently. One of those 3 triggering mechanisms must occur for any case to go any further at the International Criminal Court. It's not the end of the story, it's just the start of the story, really. There are 2 other admissibility criteria, both of which must be satisfied before a case can proceed. So assuming that one of the triggering mechanisms has actually been triggered, been initiated, then the International Criminal Court has to be satisfied of 2 additional criteria. The first of those applies only to triggering mechanisms 2 and 3, not to the first triggering mechanism where the case comes by way of UN Security Council referral. If the case comes by state party referral or by the prosecutor acting on their own initiative, then the ICC has to have the consent of either the territorial state, the state on whose physical territory the alleged crime has occurred, or the consent of the state of nationality, the state whose national is alleged to have committed the crime. And without the consent of one or other of those 2 states, the ICC, the International Criminal Court, is precluded from dealing with the case. If either of those 2 states, in lots of situations of civil conflict, the 2 states are in fact not separate but one and the same. So in those circumstances, the only state that can consent is that state. If the ICC doesn't have the consent of that state, it can't proceed. But if either of those 2 states, in situations where they're separate, have already ratified the Rome Statute, if they're already a state party, then they have already deemed to have given their consent. And then the ICC is able to deal with the case. If neither of those 2 states, if they're separate, has consented to the court's jurisdiction, either of those states is able to exercise a de facto consent, a consent ad hoc to give the case to the court. And if they do that, then the court is able to proceed to consider the next admissibility criterion. So the second criterion is what is called the complementarity formula. This is where the ICC is only a complement to national jurisdictions. And this particular formula applies to all 3 triggering mechanisms, whether the case comes to the court by way of Security Council referral, state party referral, or the prosecutor acting on their own initiative. The International Criminal Court has to be satisfied that the territorial state and the state of nationality are both either unwilling or genuinely unable to deal with the case themselves. If either of those 2 states is willing and able and actually wants to and is exercising their national jurisdiction, that exercise of national jurisdiction takes priority. The ICC is precluded from dealing with the case. But if both of those states are either unwilling or unable to deal with the case, if they're not doing anything about investigating and prosecuting those allegedly responsible, or they just don't have a functioning legal system that is capable of dealing with the case, then the ICC is able to be satisfied that this complementarity requirement is satisfied and proceed with the case. A little bit tricky, I know, but it's difficult to talk about who's afraid of the International Criminal Court without understanding the basics of how the jurisdiction works and some of the limitations to it. In addition to those jurisdictional requirements, one or other of the triggering mechanisms, the 2 admissibility criteria being satisfied, there are additional prosecutorial policy issues. The prosecutor has publicly promulgated a policy statement And in it he says that he, in addition to being satisfied of these other requirements, will look at the gravity of the alleged crimes, look at those most responsible for them, and also the demands for justice. In making his decision, in exercising his discretion about who to issue indictments against and who not to issue indictments against. The resources of the Office of the Prosecutor are limited, and just like in our own domestic legal system, the prosecutor has to choose who we're going to try and bring cases against and who we aren't. All right. And by all means, in questions and answer time, ask me some, if you want to, about these jurisdictional aspects. But let's get to the guts of the topic. Who's afraid of the International Criminal Court? And as I indicated earlier, there are a number of different categories of individuals and governments, I think, that are afraid in different ways and for different reasons. But I should start out by just saying that not everybody is afraid of the International Criminal Court. I'm certainly not. I think I told you what I think. Those who have never committed a war crime, crime against humanity or act of genocide have nothing to fear from the International Criminal Court. And, or maybe that's a comfort. But there are actually a lot of people and a lot of governments that fall into that category. And many of them have actually signed up to become states parties to the court. In addition, those who've never been responsible and aren't ever responsible in the future have nothing to fear. But any state that has a bona fide investigation and trial process happening under its own national jurisdiction also has nothing to fear from the International Criminal Court. This complementarity requirement is absolutely fundamental to the admissibility of a case to the court. And if a state takes seriously its primary national obligation to exercise its own domestic jurisdiction and does that, then the ICC doesn't have a role to play except to say, well, good on you, because we can't do it all ourselves. The International Criminal Court actually needs states to be taking seriously their international obligations in respect of the prosecution of international crimes. And tragically, there are too many of them going on. Too many war crimes, too many crimes against humanity, too many acts of genocide for a single International Criminal Court to deal with all of them. So the ICC depends on, for its efficacy, in fact, on a very effective, proactive, national set of jurisdictional, the exercise of jurisdiction around the world. And that's something the prosecutor keeps on reiterating. In Australia's case, I don't think the Australian government or the Australian Defence Force is afraid of the International Criminal Court. As a consequence of deciding to ratify the Rome Statute, which the Howard government did despite, some of you might remember, there was a pretty intense public debate in this country about whether we should or shouldn't sign up to the Rome Statute. There were what I would characterise as hysterical claims presented in writing and in oral presentations to the Joint Standing Committee on Treaties about why we ought not to sign up to the Rome Statute. I think the most hysterical of them, in my view, came from you like this, well, maybe you won't, you might think it's pathetic, but it was a Sydney person who said that the real reason the Australian government was enacting back in 2000 the legislation that enabled the call out of the Australian Defence Force was because that was ostensibly done prior to the Olympics in the case of a terrorist incident at the Sydney Olympics, and there might be a need to deploy Defence Force resources because police forces wouldn't be capable of dealing with the situation. The real reason this legislation was enacted was because when the people of Australia discover that this government is contemplating the possibility of ratifying the Rome Statute and devolving our sovereignty to these faceless judges in The Hague, the Australian people will rise up in violent protest against it, and the government will need to call out the Defence Force to quell that revolt. Well, that's great. I think there were a lot more sensible queries asked about the merits of Australian participation in the Rome Statute, but in the end the Howard government signed on. And they did that because Prime Minister Howard, then Prime Minister Howard, was convinced by the Chief of the Defence Force and by the Defence Minister that Australia did not need to fear the ICC taking away or usurping our primary claim to national jurisdiction. If a member of the Australian Defence Force committed a war crime, a crime against humanity or genocide, or alleged one of those things, as long as we had the domestic legal framework in place to be able to prosecute that offence ourselves, we could choose to do that. We chose not to do that, then that would be our choice, but at least we would have the choice. And so our implementing legislation for the Rome Statute, the International Criminal Court Consequential Amendments Act of 2002, represents the most significant and wholesale change to Australian domestic law in terms of the implementation of international crimes into our domestic law than anything that's ever gone before it. Legislation comprehensive and systematic, covering all the crimes in the Rome Statute, enacted not for noble but ignoble purposes, just to protect ourselves by this principle of complementarity. If we choose to exercise national jurisdiction, we can do that. Court can't say Australia is genuinely unable because it doesn't have the legislation it needs. I think actually one of the greatest contributions the International Criminal Court has already made is to provide this catalyst to states around the world to get their own domestic legislative frameworks in order. Our domestic framework, legislative framework for the implementation of international criminal law into Australian domestic law was pathetically inadequate prior to our decision nationally to ratify the Rome Statute.